Hi, I would like to submit this form for Turn 8. This form has already been signed by Mrs. Mistria. Sure, sir. The appellant in this case claimed that Mr. Mistria is the attorney of the second respondent. The form was submitted with copy of an office document, even though the photo state copy was signed by a witness, Sarati, but it was not signed by the second respondent. The mentioned copy was also endorsed by the Registrar of HIDAYAH as the office certified copy, and the true copy had been deposited to the court. Based on Section 284 of the National Land Code, the applicant is required to submit the original issue document of title to the Land Office. However, he failed to provide it when he presented the form and the office copy at the Land Office. Hello, sir. How can I help you today? Hello. Actually, I would like to inform you that the original issue document of title that I need to submit to the Land Office unfortunately was lost in my custody. So I would like to apply for a fresh issue document of title. Despite the absence of the original issue document of title, the presentation was recorded in the presentation book of the Land Office. On 20 November 1979, the Land Office received a letter from the second respondent, which the second respondent said that she never appointed Ms. Ria as her attorney. She claimed that the document that purported the power was false and forged. This form did not fit for registration. I should reject this form. The collector, in his affidavit, stated that the rejection of the instruments was done accordingly by virtue of Section 298 of the National Land Code, on the ground that, first, the form was not presented with the original issue document of title, second, the document was insufficient and void as the power of attorney submitted was not signed by the donor.
Subsequently, the collector had signed the cancellation of the entry, which includes the word dibatalkan printed across the said entry. The collector then received an application by the second respondent in order to transfer the undivided shares of land to the second, third and fourth respondent. In response, the collector had accepted the application made by the second respondent, which is on the same date the application was submitted. Consequently, the appellant challenged the decision made by the collector, in which it was argued that he is the person who lawfully entitled to the share of the land on the basis that sale and purchase transaction was entered in 1979. Moreover, the appellant also declared that he is the duly registered proprietor of the land, hence he seeks for the claim of indefeasibility of title under Section 340 of National Land Code. The appellant also claimed that the collector had no power or authority to cancel the transfer, as it was argued that the transfer has been successfully registered in 1979. Accordingly, the appellant wished to strike the decision made by the collector, and the appellant also submitted a declaration that the transfer of the undivided share should be set aside. As a conclusion, the judge in Mohammed BUYONG case has decided that the appellant cannot claim for indefeasibility of title under Section 340 of National Land Code on the basis that there was no registration. In addition, the court has also decided that the registration for the transfer of shares by the respondent is valid, and on this basis, the court has dismissed the appeal.
Two law students discussing on the issue and judgment of Mohammed bin Buyong's case.
Marsha, do you remember the case law that you have reviewed in land law class today?
Yes, ATIQAH. It's a case you're pointing to is Mohammed bin Buyong's case?
Yes, you are correct. That's great if you still remember. So, since we have a quiz coming up, why don't we go through the issues and judgments in Mohammed bin Buyong's case that were discussed in class just now?
That's a good idea. Let us begin with the first legal issue that arises from this case, which is whether the appellant is entitled to the protection of Section 340 of the National Land Code.
Based on my understanding, the entry made on 14 August 1979 was a bad entry and it was never signed by the collector. If you could remember, Section 204 subsection 2 states that the registrar must register any instrument by making a memorial with his hand and seal. As far as I'm concerned, the important phrases in Section 240 are any person or body for the time being registered as proprietor of any land. It is indicated that one must first be registered as a proprietor before one's title can be described as indivisible. So, there would be no registration if such a memorial is created without the registrar signing and sealing it. Furthermore, the court also referred to Section 217, subsection 2 of the NLC, right? But do you remember what Section 217, subsection 2 is about?
Oh, Section 217, subsection 2 deals with the transfer of an undivided share. It says that an undivided share of any land transfer shall pass and vest in the transferee only after the transfer is registered.
Yeah, true. That is why the court decided that the appellant did not entitle to the protection under Section 240 because there was no registration at the beginning. If I'm not mistaken, there is another issue that has been mentioned in this case, which is whether the collector was correct in law in cancelling or deleting the entry made in the register. Do you remember what the court says about this?
Oh yes, I do remember. It was held that the entry made on 14 August never attained the sanctity of a memorial of registration within the Section 3 or 4 subsection 4 of NLC. Hence, the cancellation can be properly executed.
Wow, that's really interesting. So what about the power of the collector in cancelling or deleting the entry made in the register? Is there any specific provision mentioned about this?
Here's the thing, if we look into Section 380 of the Code, it only mentions the power of the collector or registrar to correct the errors. However, it doesn't speak of cancellation or deletion.
Oh, I see. Well, if we look into Section 282 of NLC, it has mentioned the words cancellation and deletion. Nonetheless, I believe that it only touched that relating to endorsement. Thus, it is not clear on what of corrections can be authorized under Section 280.
Yes, you're right. Anyway, there is a case which highlighted by the court in this current case. Can you guess the name of the case?
Is it the case of Island and Peninsula Development Berhad and another against legal advisor Kedah? If yes, can you tell me more about that?
Brilliant. Yes, you're correct. In this case, the High Court decided that Section 380 subsection 1A of the Code applies only to errors or omission made by the Registry of Land Titles and doesn't apply to errors or omission made by the parties involved. However, David Hong stated on his board that it may refer to administrative mistake and that it should be wide enough to include other circumstances. Here, the Judge Hashim Yop further elaborated that Section 380 subsection 1B will be wide enough to include any entry that was wrongly recorded by the registry. Hence, the court adopted common sense attitude in the current case.
Oh, well, so it can be inferred that it is a proper statement of the law to assert that the collector has no power to amend or cancel a memorial because the collector is functus at the time the memorial is made.
Yes, you're on the right track. So how about we move to the last issue?
Of course, sure. The last issue is whether the collector acted unlawfully in registering the transfer on 4 January when the entry made on behalf of the presentation by the appellant still remained uncancelled. I believe you are aware of the relevant section that the court used to address the last issue.
Definitely Section 300 of the NLC. It provides that the registrar shall not register any instrument until every instrument presented prior to it. So in respect of the same interest has been registered, rejected or withdrawn.
Indeed. Basically, the collectors act in registering the instrument of transfer to the second, third and fourth respondents appears to be in violation of Section 300 because the entry was not cancelled or deleted until 21st January 1980. However, the court observed that the facts of this case should be considered as a whole. So, the words "shall not register" in Section 200 subsection 1A are merely recommendatory rather than mandatory, and the collector's apparent failure to follow with the section did not nullify the registration on 4th January 1980.
That's really a long discussion of Mohamad bin Buyong's case. So, from this case, we understand that the power of the registrar played a huge role in registration. Here, it is important to note that in order for registration to be effected, the instrument of dealing must be presented to the registrar.
Yes, Marsha. As we all know, any dealings cannot be registered if the memorial is not signed or sealed by the registrar. Apart from that, the registrar also can refuse the registration for unfitness.
Oh yes, it is clearly stated in Section 297 of the NLC that the registrar has the power to determine whether it fit or not for registration. If it fit for registration, then the registrar may register it.
I think that's all for our discussion. Thank you, Marsha, for today. I'm so hungry right now, so let's take a break.
Thank you also, ATIQAH. Me too. I'm also hungry. Let's head to the cafe.